there's a going case. Are you suggesting by that you wouldn't want to answer the question, or you're giving an answer that may require somebody to interpret?
The criminal case is before the East London Magistrate Court, and his clients are involved in that matter, where they are alleging that I shot a firearm on the stage in an open space where there was public. Whatever answer I give here will have implications on that matter. And he's asking it knowing that there is such a matter before the court. So I will not be answering it.
You're embracing the Constitution, is that correct?
Yes.
You embrace the Human Rights Commission as a chapter 9 institution?
Absolutely.
Now, the Human Rights Commission was tasked with this question to determine whether the song Kill the Boer, Kill the Farmer amongst the hate speech. And I'd like to read you what their finding is and some of their reason. The final determination was the slogan, Kill the Farmer, Kill the Boer, has transferred the ANC rally in Kimberley and at the funeral of Peter Mokgabe and Paul Pane is hate speech as defined in terms of section 16(2)(c) of the Constitution. And that tribunal held the slogan under consideration as appeal was transferred in high-profile functions organized by the African National Congress, the ruling party in this country. These events and the chanting of the slogans were widely publicized. There can be no doubt that the slogan, given its content, its history, and the context in which it is chanted, will harm the sense of well-being, contribute directly to a feeling of marginalization, and adversely affect the dignity of Afrikaners. The slogan says to them that they are still the enemy of the majority of the people of this country. It contributes to alienation of the target community and conveys a particularly divisive message to the majority of the community that the target community is less deserving of respect and dignity. This generalized slogan is directed against an entire community of people, words convey meanings and do cause hurt and injury. There is a real likelihood that the slogan causes harm. What is your view on the finding of the Human Rights Commission?
You read long things.
Sorry, I beg your pardon.
So thank you, my lords. The first problem is that is one of many other findings of the very same institution on the same subject matter. What is put to the witness is one version, not the second version, which found the exact opposite of what is being suggested. Prejudice one. Hold on a second, just answer the question.
Sorry.
The implication is that there's a second version. This is the appeal tribunal. This is the higher authority. The implication is being drawn as that let's let the witness by reading something that you overrule. Yes.
Mr. Kasibuta?
I insist, Your Lordship. There are two decisions coming from this process which vary, and one version is given to the client, to the witness. That's the first prejudice. The second is this. It's being asked as a lay witness to interpret the law. It's being asked to interrogate. Firstly, to not have the benefit of reading what he's referring to. Does not know the merits and the demerits of what he's referring to. And then he's asking him to make a legal analysis on the basis of the document he's read and or consulted on. The third prejudice is that is precisely why we're here. He's being asked to give an opinion of what this court will find. That's the essence of the question, and that can't be listened.
Well, before I give Mr. Oppenheimer an opportunity to respond, but on the first question, he's read to him the decision of the appellee, of the appeal.
Yes.
Why can't you address the shortcoming in that question in reply? Because I would assume that in your reply, you could say, was this the only finding related to the Human Rights Commission? And that can be clarified at that point.
Yes.
So that doesn't seem to me to sustain. But I would want to get the comment by Mr. Oppenheimer on the second point of it seems to come back to the issue of an opinion. Nearly said prejudice, it doesn't, because that was finalized, as I understand.
asking the witness for his legal expertise. I'm asking him to respond to the finding of that Human Rights Commission Appeal Tribunal. They made a finding on this question on disclosure of killed body of a farmer, which of course an issue also. You have a chance to respond to both sides. It doesn't usurp the power of this court to make determinations about this present matter.
I don't seem to see any problem with that, Mr. Kasiboto, because all what the witness has been asked, your comment. And you can comment and say, look, this is what the Human Rights Commission found. I agree with them, or I don't agree. That really, for me, it's something that the witness should do.
You are trying your luck. You are trying your luck.
What's that?
You are trying your luck because, my lord, this question is asking me about is before court. It's on another court. It's trying his luck now.
It's a simple question. You can say yes or no.
Yes.
This matter you are asking me.
Okay, sorry. Yes, Mr. Kasiboto.
You know, Chief, I think that point is clear. Can't persist with that line of question, honestly. Well, the witnesses said that they find guns that they think is, and don't use real guns. I'm asking a simple question, which is whether he will use a real gun at this stage. Yes,
But to what extent would his answer seem to be there is another case related to the shooting of a gun? To what extent does the answer he gives prejudices or may prejudice whatever is happening in the other court case?
Does he want to say that he doesn't want to incriminate himself? That might be an answer you could get.
Yes, Mr. Kasiboto.
Your Lordship, whatever form of an answer gives is prejudice, regardless of what the response is. The matter is lies before court. We're talking self-incrimination in fundamental constitutional rights here. The answer is clear. I will not answer the question before another court. However, it raises the question, if it relates to the merits of that, or has an implication to it, it can't be required to answer that question.
You see, sorry, I beg your pardon, Mr. Oppenheimer. My concern is sitting here, and this is a matter that may require a serious interrogation, because the essence of the answer he's given is, I'm not going to answer that question because that issue is before another court. Sitting in this court, being a different court to the ordinary courts, what crosses my mind is, how do I interrogate that issue? And to what extent could the court be blamed for if it permits the question to go through and the answer be given? Because we don't know what answer he's going to give. And the consequence thereof result in the complication of prejudice. And I may be incorrect, but the sense I get, it's referring to a criminal case. Well, you see, also there we now confronted with a situation where this court doesn't apply the same standard as the standard that would be used in that court. That court uses a very high standard. And this court uses ordinarily a much relaxed standard. In fact, much relaxed than even the ordinary civil court. Aren't we running into the risk of compromising certain constitutional rights?
Well, the witness himself, they said we don't use real guns on stage because we are engaged in the Roman metaphor. Now, I asked them a simple question, which is, would you use a real gun on stage? Now, at this juncture, you can say there are court proceedings on that very issue. On that basis, I would answer it.
That's what he has said. I thought maybe he didn't put it in those. That's my interpretation of what he said. But maybe let's just